Thank you. We'll take the matter under advisement. Next is Major versus Maguire. If counsel could please step forward. We're going to wait for Judge Cuff. Take your time. May we please have appearances of counsel?
Good morning, Your Honor. Teresa Lyons from the law firm of Lyons & Associates on behalf of Petitioner Julie. Good morning, Justices. Tomaio Newmark of the firm Townsend, Tomaio Newmark on behalf of Anthony and Suzanne Major, the respondents and the grandparents. Also present is my partner, John Clancy, who is present at the trial level.
Good morning, Your Honor. It's Brian Paul with the Schaefer & Lakin firm appearing on behalf of the New Jersey State Bar Association.
Welcome, counsel. Ms. Lyons, you may proceed.
Good morning, Your Honors. May it please the court. Again, my name is Teresa Lyons, and I'm here on behalf of the petitioner. I ask at the outset to be permitted 3 minutes of rebuttal after the respondent and also the bar.
That's fine.
Thank you. I stand here this morning on behalf of Julie DiLiberto. Equally important, however, I stand here on behalf of the countless fit parents across the state of New Jersey. And I think it's important from the beginning to note the words of Justice Long in the case of Moriarty. Justice Long was a respected jurist with a vast knowledge in family law. And what she stated in Moriarty is as follows, quote, "It bears repeating that a dispute between a fit custodial parent and the child's grandparents is not a contest between equals. It is respectfully submitted that every question asked, every answer given, every analysis made must be considered within the confines of that constitutional command." Respondents basically give 3 arguments as to why they believe the holdings below must stand. Number 1, they cite procedural irregularities. Number 2, they believe that grandparent cases should no longer be summary proceedings. And number 3, they allege that harm need not be shown before discovery and other litigation should ensue. First, with respect to the procedural irregularities that they might allege. And with no disrespect to the grandparents in this case, if they are going to live by that sword, so too must they die, because there were procedural irregularities regarding their own complaint. Daniels requires that the pleadings be done with particularity. The trial judge below found that the pleadings were not done with particularity, and so therefore the trial judge, not required by the rules, who could have outright dismissed those pleadings on their face, nonetheless permitted the grandparents to come back the next day and supplement their inadequate pleadings by way of testimony on the record which was unrebutted. That was a procedural irregularity that the grandparents were afforded. Second, within that, even if there were procedural irregularities, I would remind this court, it is not a contest of equals. It is never a contest of equals. Next, there's a notion as to whether grandparent visitation cases should be summary proceedings. It respectfully is submitted that they should be. The arguments are, well, the issues are too messy. The matter is too complex. We referenced in our response to the amicus the notion of DEPIS and the Prevention of Domestic Violence Act. That is an area of family law, the Prevention of Domestic Violence Act, where I would submit that the issue at hand are probably far more serious. The issuance of a final restraining order, the fingerprinting, the placement in the registry, the negative inferences in future custody proceedings. And yet those are done on a summary nature. Third, respondents take the position that no harm should be shown before discovery ensues. Now, I know that the case of R.K., it doesn't seem petition for certification was filed. Your Honors are aware procedurally that our case at the appellate level was heard after R.K. had come out, so we could not have known about it prior thereto. Harm, the Constitution commands that harm must be shown. And not only the notion of harm, but particular harm. Misra is clear that a general loss of memories is not enough. Daniels is clear that an ordinary grandparent relationship is not enough. Rente is clear that the harm must be particular, identifiable to the specific child. The trial court below heard the statements of the grandparents. Their pleadings fell short. They gave only generalities. And even within those generalities, Your Honor, we would submit that there was some level of disingenuousness. For example, the grandparents alleged at the trial level that the child was not permitted to come to the funeral. And what was ferreted out was that the child was permitted to go to the funeral, but the only remaining fit biological parent said, "My daughter is 5 years old. She's really shaken by the loss of her father. Of course my daughter should go to that funeral, but I would like to go with her as her parent." And the grandparents said, no. The grandparents made that choice. The grandparents were still seeing the child. Interestingly, Your Honor, we objected in opposition to amicus. Respondents attached a number of other additional correspondences that were not part of the record below, trying to show that parenting time has been thwarted. If you look at PA 85 within that appendix in the opposition to amicus, there's an email where the grandparents say, "We would like to see our granddaughter." And the mom says, "Well, you saw her last month, and I invited you to her birthday party last week, but you didn't come."
Could I stop you there for a minute? Because
Yes.
the facts that you are describing are not necessarily what's at issue here. Assume for a minute that everything you've said is correct. How does a person, a grandparent, preparing a pleading, describe particular harm to the child by reciting facts? How do they do that without expert testimony or expert evidence of some kind? How could they ever meet that standard?
Your Honor, it's a very fair question. I would submit
Thank
it
you.
happens in family law every day. And I would liken it, for example, when we have post-judgment applications to modify support. A lot of times those applications are made without forensic experts, without new case information, so with all kinds of
It's a
things.
very
little
different
bit
situation.
than the particularized harm, the psychological injury, the damage to a child. That you can't add, subtract, multiply, and divide that. I'm just asking, how do they provide that without something beyond their factual assertions, which is all we have at the complaint stage?
Your Honor, I don't disagree that many times it's predicated on factual assertions. I believe Your Honor is correct, and there's a panoply of factual assertions that the case law outlines, that the child has been seen in a state of sadness, that there's been anguish to the child, where they actually plead particular facts. In this case,
And
Your Honor.
let me ask you this, if I may, Justice Solomon.
please.
If your adversary made that factual recitation, you would be very effectively and very quickly in court saying they have no basis for this. There's been no psychological evaluation. What is a state of sadness? That's not in the DSM. That they're not talking about any particularized harm. How could, and just following up on the same question, give us, take yourself away from your own case for a moment. I'm not asking you to concede anything on your own case, but give us a showing of harm without access to the child, because the child is not going to be hauled in generally to get in the middle of this, that grandparents could possibly make that would meet that showing without the assistance of expert testimony.
Your Honor, there's a couple things I would say. First, the case law has delineated and is actually specifically said expert testimony is not needed because, Your Honor...
Well, no, Moriarty refers to expert testimony as being a basis for this.
But it also says that expert testimony is not required. And when we go to the notion of particular pleadings, in fact, what the case law has held, that grandparents who are truly in a position enough, this is part of the issue, Your Honor, grandparents who are truly in a position enough that have been a primary caretaker, that have had other extraordinary circumstances, should not need expert testimony because they already possess the facts.
So give me the pleading that would meet a standard of showing of harm to the child, not just the fact of caregiving in the past, but showing of harm to the child without discovery, either fact or expert.
I would note a couple things. First, Your Honor, with regard to the FD complaint, a lot's been made of that it's just a little form where people check. I would recommend, and this is actually what I do with my clients when I am litigating for the grandparents. We not only take that 2-page form, and in fact, if Your Honor looks at the pleadings, when we responded, we took the 2-page form, and then we did the underlying certification. That's what counsel usually does.
Let's not. I'm sorry. My question was unclear. I'm not talking about the summary complaint or anything like that. I'm talking about what is the factual showing that you would substantively put in there that would meet the standard of showing the harm to the child without discovery.
I'll give Your Honor some examples I can think of. Let's say there should be particular harm could relate, for example, the child and the grandparent always used to do this together. Grandpa was always the coach of Little League, and now he can no longer be the coach of Little League, and that causes anguish and embarrassment to the child.
And isn't that why the court allowed the grandparents to testify and supplement their complaint, because they did use a standardized form, it contained none of those facts, and they went on to explain what they thought was this harm, right? That's why they did that.
Yes, Judge.
All right, now, yes.
Yes, Your Honor.
So let me ask you the second question. The judge, however, precluded the grandparents from offering the testimony of an expert, again, to supplement the complaint, to set forth that particularized harm, correct?
Yes, Your Honor, but not just for that reason.
Pardon me?
Not just for the reason that he hadn't found harm yet. There were other reasons in the record why he had not permitted that expert.
Such as?
Such as that the expert had not met with anyone, there were generalities, there were hearsay, all kinds of things.
So what? And I'll tell you why. So what? Is there anything stopping a grandparent from attaching to the complaint a report of an expert saying a child under these circumstance as they're set out in the facts they testified to would suffer from this particularized harm? Anything preventing that from being attached to a complaint is Exhibit A to substantiate the particularized harm.
I don't believe there's frankly in your initial pleadings, I don't think there's anything that precludes anyone from attaching anything. That said, it would be an infringement upon the constitutional rights of fit parents in this contest of non-equals if the child or the parents were required to participate in that pre-finding of harm.
Not saying they are. Expert says in his report or her report, based upon the facts grandparents are describing in the complaint, in this case are testifying to, the following particularized harm within a reasonable degree of certainty would occur to this child. Does that then not meet the standard?
I don't believe it would, Your Honor, because the case law is very clear, and in particular, Your Honor, the case of Rente. It must be a particular harm, it must be identifiable, and it must be specific to that child. And
Doesn't
so-
it sounds like-
The plaintiff get this is a pleading, so we have to remember, this is not a contested case. On the pleadings, the person who is pled is entitled to every reasonable inference that can be drawn from the pleading, correct? So the benefit of every favorable inference.
Yes.
That's the way we're supposed to read pleadings, correct?
Yes, however, I would temper that, Your Honor, because there's a particular case, and I believe it's Daniels, that says grandparents are compelled, are constitutionally commanded to do more than notice pleadings.
No, I'm not saying that there shouldn't be within the confines of particularized pleadings, and take the testimony that was given as the particularized pleadings. From those pleadings, they're entitled to every favorable inference that can be drawn from them before that complaint is dismissed, correct?
Yes, Your Honor, and what happened in this case, as the court is aware, is that the fit parent was not even permitted to cross-examine.
But you don't cross-examine a pleading.
You're right, Your Honor.
So, I mean, the court permitted the supplementation, perhaps because there was confusion caused by our court system. Because the administrator of the courts had authorized particularized pleading, which in RK had caused some amount of confusion, and may have to the parties over here. So they completed the form that our court said was authorized for a summary proceeding, and the court here recognized that maybe that caused some confusion, and in his discretion permitted the supplementation. Anything wrong with that?
Nothing wrong with that, Your Honor, and in fact, if Your Honors look at the transcript, counsel is asking the respondents, what's the harm? And one of the respondents says, oh, well, the child was just ripped away from us. And another one of the respondents says, well, it's just not right. We didn't have control over the fact that our son died. They didn't, even when they were given the opportunity, with no cross-examination.
They did quite a lot. I mean, they did more than I think you're suggesting. They said before the death of their son, they saw the child every other weekend. Then they was seeing the child every weekend. The grandmother was taking time off while her son was sick, and picking the child up from schools on Thursdays and Fridays, cooked meals. I can go on and on. There was a lot that was testified to at that hearing.
You're right, Your Honor. Respectfully, however, all of those notions that Your Honor has delineated go to the other factors of the best interest. If you look at the grandparent visitation statute, NJSA 9:2-7.1, those other factors of the caregiving, everything else.
With all due respect, they go to whether or not there's a foundation for establishing whether or not there was a profound relationship between the grandparents and the child. And you have to look at that also in the context of something else that Justice Long had said, that these cases of harm are more likely to arise when there's the death of a child. She specifies that. She even said in other states the death of a child constitutes harm alone. Now, we haven't said that, but we have a death of a child, and then we have what looks to me like particularized pleadings in the testimony to supplement the death.
Your Honor, respectfully, we do not believe that those pleadings were particularized. And I would note,
But how do you say that? When we were talking a little bit earlier, you said, "Oh, if they show they were coaching Little League and can't do it anymore, that might be it. Can't have expert testimony, so can't focus on other than a general idea of sadness." But I suspect you would probably say that wasn't sufficient. And now, in response to Justice Albin, you're saying, "Oh, well, all those things about all the prior involvement of the grandparents in the child's life, that just goes to best interest." So it seems to me that basically what you're saying is there is almost no way to meet this standard.
Your Honor, I want to again go back to the record. if you look at what was testified to, at their best, we have this one grandparent that lived in Pennsylvania, an hour and 45 minutes away from their son who died. At best, it was testified that she lived with her son full-time for 3 months before he died. At best. And so therefore, if you look at that, you could say maybe for a 6-week period of time, this grandparent was there to help their child parent?
That's not our issue. Our issue is not to make the ultimate determination as to what the outcome should be. Our issue is, in light of Moriarty and in light of RK, should the grandparents have been given an opportunity to either supplement the complaint further, and that's kind of what I was hitting on, by offering an expert report or providing that expert testimony to supplement the complaint so that somebody could say, because whatever the grandparent says is going to be inadequate according to your position, that a child that is going through this kind of relationship with their grandparent, whose parent dies under these circumstances, is going to suffer the following particularized harm, in my opinion. And then, if they can do that, then we begin the process of the case management conference, the discovery. In other words, we're not trying to get to the outcome. We're just trying to figure out what is adequate to make, at least to get past the pleading stage. And you're basically saying nothing. And all I'm suggesting is, going back to what happened here, the court having supplemented the record correctly in the complaint, the complaint by the testimony of the grandparents because of the issues that Justice Albin described. How do they then say, well, you have an expert who's willing to give us that particularized harm, but that person can't testify and supplement the record, and we're certainly not going to give you an opportunity to file that report and tell us. And if they can do it, maybe you take the next step. If they can't do it, you're out of court. How do we justify that? How does anybody ever meet their burden or their standard if something else doesn't happen in a case like this?
Well, Your Honor, I think that again, I go back to, this is not a contest of equals, and I would submit, I think the bar is correct where it says, listen, on the face of the pleadings, then there should be an automatic motion to dismiss scheduled. I also want to address the notion of, as soon as a parent dies, maybe that on its face should be prima facie.
No,
we're not saying that.
Child.
Nobody's saying that.
No one's suggesting that.
Stay with the facts of this case and tell us what more would be needed to avoid a dismissal. You have the pleading that speaks about a long-standing relationship and the substantial involvement of the grandparents. You have testimony that Justice Albin went over, and there are some additional facts as well, and the proffer of an expert that is not permitted to testify. What more is needed to avoid dismissal?
Your Honor, the trial court, in its sound discretion under Cesare v. Cesare, found that there was no harm. And I don't know that this court and the Appellate Divisions have had a long history of sustaining findings of fact by a judge, because there were other things.
With all due respect, that's not a response to the Chief's question. The Chief is asking us what would be the showing, and if you want to take yourself out of your case so you don't give them a roadmap, I think, to how to do this, what would be the substance and the quality of the type of evidence that would get someone past that showing?
Well, the cases have spoken about this. So, for example, the losses of memory are just not enough. A typical grandparent relationship is just not enough. So, for example, in this particular case, the grandfather testified that when his son got ill towards the end when he was having treatments, Grandpa used to babysit him. Okay? That's what he said. And if you look at grandfather's testimony, before that, he was not a caregiver. Absent, I would have to say that a grandparent would have to show that they were a long-term, consistent, primary caretaker of the child, not a joining in on the father's parenting time. And it's interesting because the grandparents in this case, by the way, are still seeing the child.
Where do you get that out of Moriarty? Where is that? Where can that be found to be the standard? A long-term. How likely is it that of all the possible child care arrangements that people make, that someone would have a particular grandparent as the primary caregiver for most of the child's life?
Well, let's put it this way, Your Honor. Maybe on Moriarty it doesn't need to be most of the child's life, but I would submit that the Constitution commands more than 6 weeks. And that's what happened in this case. If you look at the transcript...
It's not just 6, you're talking about 6 intensive weeks, but they had a continuing relationship with this child. Weekends, trips to Disney World, to their summer place. So this isn't a 6-month gig. Okay, this is a relationship over the entire life of the child. No? Based on the pleadings, based upon what they said.
And what they also said, Your Honor, is that every single one of those engagements was when their son was there, and in this case what they're asking for is now what they didn't have with their own son.
We're not
If
here
you
to
look,
argue the case.
The son is dead. How could they have a relationship with the child with the son? That's just it. That's the problem.
What I'm saying, Your Honor, is the grandparents have continued to see this child, but because it's not on their terms, they don't want it.
Maybe you get to prevail in the end. The problem at this point is the complaint was dismissed without the matter proceeding. Why wasn't there an adequate prima facie case presented to avoid that here?
Because when they were asked the question, what is the particular harm? They were both, if you look in the transcript, the lawyers asked each litigant, what is the harm to your grandchild?
And they gave a layperson's response one would expect from a grandparent, and then offered to present the testimony of an expert. Shouldn't we look at that all together?
Your Honor, candidly, I think that grandparents, the Constitution commands that they be held to a higher standard. They don't get 2, 3, 4 bites at the apple. I would also note, Your Honor, it was dismissed without prejudice.
Then this goes to the expert. If you don't like their lay assertions, because all they could do is speak from their own viewpoint, you would have objected had they started doing a psychological analysis of the child. But then the judge did not permit, for purposes of supplementing the pleadings, for the expert to give testimony.
Your Honor, absent harm, I am not standing here today saying that this is easy or not personal. But the Constitution commands that there be a particular, identifiable, specified harm at the pleading level.
So you're saying the dismissal was out without prejudice, correct?
Yes.
So there was nothing preventing the grandparents from filing an amended complaint, setting forth the facts they testified to, and attaching as Exhibit A the expert's report.
They did none of that, and they've been seeing the grandchild all this time. That's the other thing. One of the other things that the court found was there was no finality here because they continued to see the child.
Are they precluded at this point from filing that amended complaint?
Your Honor, I don't believe that they're precluded from filing the amended complaint. I think they would have an even larger hurdle.
We're not deciding it. I'm just
I don't think that they're precluded. I don't think as a matter of procedure. I think it would be disingenuous for me to say that to Your Honor. I think there were many things that these people could have done better. People who were represented. These are not pro se people. These are people that are represented by extremely competent, highly respected family law counsel. And there has to be a showing of harm. The Constitution commands it. And to do everything else, to permit an expert, to permit the interrogatories, I would remind the court that litigation is expensive, litigation is inconvenient, and litigation has the potential to re-traumatize.
So you've all, in a case, you've given the example if the grandparent lives with the child.
Yes.
Okay. Now, if the grandparent pleads that, the grandparent is still may not be in a position, if the grandparent no longer has contact with the child, to specify the psychological harm. Are there not inferences that could be drawn from even the circumstances that you're suggesting?
I have two responses, Your Honor. First, the statute says that if the child lived with the grandparents, there's a presumption of harm. So that takes care of itself, Your Honor. We don't need the inferences. But if you're asking me whether inferences should be drawn, my answer would be no, because people who are not equals under the Constitution do not get inferences. The only people that get inferences in their favor pursuant to the Constitution are the fit parents. That's what the Constitution commands.
Well, then you are rearranging our law on pleadings. Are you saying that a motion to dismiss on a pleading is different in this case from other cases? Is that what you're suggesting? That when someone pleads, that they don't get the favorable inferences drawn from the allegations?
I actually am saying, Your Honor, they get favorable inferences only if they plead with particularities as mandated by the Constitution. Yes, that is what I am saying. They get all favor inferences if they plead with particularity.
I thought you just said that because they're not equal under the standard, they don't get inferences.
If they plead with particularity, that's what they're required to do. They don't just get inferences.
Why shouldn't we be encouraging the involvement of experts in these cases? And we have experts in issues dealing with children. The courts are enormously respectful of and dependent on the judgment of experts, sometimes court appointed, sometimes presented by the parties. Why shouldn't, on this extremely important issue of grandparent visitation, why shouldn't we be encouraging parties to get experts involved?
At the risk of angering the court, then I'd like to answer the question with a question. Why shouldn't we then be encouraging experts in the domestic violence realm? Why shouldn't we be encouraging experts in other FD dockets? Because they're FD dockets and the Constitution commands that we're not supposed to do it. If we say, well, we're going to determine that this area of FD docket is so important that there should be experts, I would submit, Your Honor, frankly, that the notion of domestic violence, and this court has specifically found, and the legislature has found, that domestic violence is a serious epidemic in society. Frankly, it's statutory.
Hang on, take a deep breath. The finding of domestic violence is a very different finding from the kind of finding required here to determine whether the injury to the child has been adequately pled. This is a little bit different. And let me just go just a step further. There is nothing precluded. I don't know if anybody up here is thinking about requiring that an expert's report be filed, whatever. All I'm suggesting to you is, isn't that an option of a grandparent seeking visitation to provide an expert's report to substantiate the claim of particularized harm? Isn't that an option?
I guess so.
Well, yes or no? It seems like an easy answer to me.
You know what, actually, I think I'm going to say no, because it's not permitted in the domestic violence realm, and I know Your Honor is saying it's different.
It's not? It's precluded?
You have to make an application before you're permitted under DEPOS and everything else.
To provide an expert report to substantiate a complaint?
For domestic violence.
I'm not talking about domestic violence.
You're comparing apples to oranges by raising domestic violence as a comparison, because I can't. It's hard for me to see in a domestic violence case where you're resolving an issue of an assault whether or not you're going to need expert testimony. So you should really stick to this case instead of using domestic violence as a stalking horse.
Well, if I may, Your Honor, my favorite movie is My Big Fat Greek Wedding, and when they talk about apples and oranges, they do admit they're all fruits. And I would say this, Your Honor, that there are notions of domestic violence that could be subject to experts, like patterns, because as the court is aware, when there's an ambivalent predicate act.
So when we get the domestic violence case before us, maybe we'll look and have to reform the procedures there based upon what you're suggesting to us. But it's not really helping us in trying to figure out what we should be doing here.
I guess my point is, we believe what the court should be doing here is it should remain firm in the 15 years of jurisprudence as mandated by Troxel, the 14th Amendment, the grandparent visitation statute itself, Moriarty and its progeny, and what that tenet of over a decade of case law holds is you must first show harm before you get anything else.
Let me ask the last question I'm going to ask in this part of the argument. Do we need to define, I guess there may be two parts to this. Do we need to
Second to last.
Penultimate. Do we need to define what is particularized harm?
I think that would be helpful.
Okay. How should we define it?
I think, I know amicus has spoken to that. I know there are actually some statutes in various jurisdictions that do
Do you want
speak
to
to what that would
for
be.
them? Do you want to wait for them?
And if it's not answered by amicus, at the risk of putting you in the hot seat, then I'll respond to that. But I
I'd
think
actually be
sometimes
interested. I would actually, because there may be sometimes amicus don't necessarily agree with the parties, and we have the benefit of both. And you're obviously a very experienced attorney in this area. What's particularized harm?
I think particularized harm would be if a grandparent was a full-time. The statute says full-time caregiver, right? The statute actually says a full-time.
Consideration.
Yes,
It's a
but
consideration.
I think, Your Honor, I think that the court could
Doesn't
infer. Your
require
Honor asked me about inferences. If a grandparent was a full-time caregiver, the statute itself says there's a presumption of harm.
How can that factor be applied when the parent of the child in issue is not a full-time caregiver himself? So how can we make that factor work in, what is a very common real-life situation?
I don't know that it ever can, and I don't know that it ever should, because
So grandparents of divorced or separated parents can never benefit from that factor of harm?
they can only if they've been a full-time caregiver at some point in the child's life, and that's what the Constitution commands. These are not equals.
So your definition of particularized harm can only be met if the grandparents were full-time caregivers.
That was one factor, Your Honor. That was the first one that I gave.
Would you like to think about some more factors, and we'll get you back up on rebuttal?
Very good, Your Honor.
Okay.
Thank you.
Mr. Paul.
Thank you. If it pleases the Court. The New Jersey State Bar Association sought permission to participate in this case because we're concerned that the Appellate Division's decision could lead to the grandparent visitation statute being applied in an unconstitutional fashion. The State Bar Association's concern is twofold. First, that the decision will lead to courts prematurely engaging in analysis of the statutory factors which are a best interest test, and second, that courts will prematurely order discovery in these cases. Now, there are two aspects of the mother's position set forth in the brief that the State Bar is comfortable adopting. First, the case law is very clear from Moriarty v. Bratt until R.K. v. D.L. that a court may not engage in analysis of the statutory factors unless it first determines that judicial intervention is necessary to protect the child from some possibility of harm. The second position we agree with is that a trial court should not order discovery in these cases unless it first determines that the grandparents have established a prima facie showing of a particular identifiable harm specific to the child warranting judicial intervention. And we'll get back to talk about what those particular identifiable harms should be later in the presentation. While the State Bar Association certainly applauds this particular appellate panel for attempting to streamline grandparent visitation cases and attempting to create consistency in their administration through the procedural guidelines set forth in R.K. v. D.L., the State Bar believes that if a court addresses items number 2 through 8 of R.K. v. D.L. without first finding there's been a prima facie showing of harm, it results in the statute being applied in an unconstitutional fashion. Simply stated, parents should not be compelled to participate in discovery, psychological evaluations, pendente lite motions, mediation, or even to have their decision on what they believe to be in their child's best interest second-guessed unless the facts alleged in the grandparent's complaint, when accepted as being true, establish that the parent's decision has placed the child at a risk of harm. And again, the reason why a harm showing is the threshold requirement is because harm is the constitutional imperative necessary for a court to validly second-guess whether a fit parent's decision regarding their child's best interest is correct or not. The State Bar, in order to balance these two competing interests, is asking the court and encouraging it to endorse a two-step process on these cases going forward. It's similar to what Judge Curry did at the trial court level. When a complaint for grandparent visitation is filed, it should be reviewed at the initial case management conference that is now required under R.K. v. D.L. to determine whether the pleading on its face has alleged and demonstrated on a prima facie basis a particular identifiable harm specific to the child. If the court is satisfied the prima facie showing has been made, then it should move on to items number 2 through 8 of RK versus DL. If it's not satisfied that the prima facie showing has been made, then we're suggesting that the court advise the grandparents to amend the complaint and schedule the matter for a motion to dismiss hearing. At the motion to dismiss hearing, the amended complaint should again be reviewed in the light most favorable to the grandparents, and if the court satisfied a prima facie case has been shown, then it should move on to items 2 through 8. Otherwise, the complaint should be dismissed.
At the MTD motion to dismiss stage, would you does your analysis would permit supplement an amended complaint, supplementation? And I'm saying that because we wouldn't normally maybe do that in a full-blown civil proceeding, but we're dealing with not only FD but also this particular type of claim that has constitutional factors. Would you permit an amended complaint? Would you permit a submission of an expert report, something as has been suggested?
The State Bar really was focusing on this two-step process and the unorthodox method of having the grandparents have an opportunity to amend the complaint, because a lot of these cases are done on a pro se basis, and these are supposed to be summary support proceedings. So we're looking for a way to have the court receive the information it needs to make an informed decision to the best that it can.
So you're suggesting any way to get the court the information that they need? Yes.
The concern we would have, and we didn't brief this, and I guess one of the problems I have speaking for the State Bar is, you can ask me as a certified matrimonial attorney what my personal opinion is, but we didn't brief the issue of whether or not an expert report should be attached or not. So I'm not comfortable taking that position for the State Bar at this time. If you want to ask me on a
limb, tell us what you think.
Okay.
There.
I think rentee versus rentee is really a decision that goes to that. You have to be careful with these expert reports at the beginning stages, because a lot of times they're net opinions. There's psychological, I believe the rules of professional conduct for the psychologists, at least they used to say, they're not allowed to give a recommendation on custody unless they interviewed the parent and the children. And now we're talking about situations where someone might come to court with a net opinion report saying, oh, there's going to be harm, and it's not based upon anything.
Let me just ask you about that, because let's assume that all of the disclaimers are set forth in the report. I wasn't able to interview the parent, the child, because of the nature of this litigation. I interviewed the grandparents, and that's all I was able to do. And here is what, I'm speaking as the expert, here is what I was advised by the grandparents. And if I accept all that as true, obviously there's not the countervailing evidence on the other side, that would create a showing of harm to the child. Almost a summary kind of report that you might see early in the stages of litigation, subject to supplementation. I
think it goes back to what the underlying facts of the case are. On a lot of these cases, and you're going to ask me, what is my opinion on what's a reasonable, what's not particular identifiable harm? The case law throughout the country really speaks to two fact patterns. One would be a death of a parent, along with a cutting off of the relationship with finality or visitation that is too limited in scope. And the second is a psychological parent case, or the cases where someone is really giving full-time caregiving. Those are what the cases really talk about. And again, I do agree with what the mother was arguing in this case. We have to remember the grandparent visitation statute is a best interest analysis. And that test is geared towards cases where we have two fit parents on level ground and the court is being a tiebreaker.
Right, but that's down the road. We're talking about here, and I think you can probably recognize, at least from the questioning, the concern that speaking for myself, I have, and that is we set up a legal standard, a substantive legal standard, and then there is a potential that a plaintiff is not going to be able to meet that standard because of limitations that are put on them, procedural limitations that are put on them.
So let me go back to what I was saying. There's two fact patterns that I'm aware of that usually constitute harm.
Right.
The facts for those patterns would be in the grandparent's possession already. They would know if the child had died. They would know to the extent their visitation was cut off. They would know what the relationship was beforehand. The expert report doesn't do anything to enhance that, and as Justice Albin noted, we're reviewing the complaint and those allegations in the light most favorable to them anyway, so we have to accept those allegations as true.
So you're saying that if the grandparents, I'm asking you, are you saying that if the grandparents say we'll use these facts. Their son died, and let's assume, I'm not saying that what the current situation is, but let's assume hypothetically that they were either unable to see the child or very, very limited in their ability to see the child, having had a prior relationship that at times was a very significant involvement of them in terms of the day-to-day life of the child. No expert. Does that meet the standard?
I have to give you the same caveat. I would be happy to answer the question, but we were
Not on
very
behalf of State
careful in the
Bar.
brief to
Yeah.
say, assuming Judge Curry was correct in finding there was no prima facie case made, we thought his decision was correct because the State Bar does not take sides.
Completely understand.
If you're asking me,
you're representing a group of matrimonial attorneys and family law attorneys who have many, many different points of view. So we understand the limitations that you have in your response.
if the visitation had been cut off with finality and they didn't come to court 6 weeks after, or if they had and they had alleged it's been cut off, that's I think what Judge Curry struggled with when I read the decision is how quickly they came to court with the complaint. I don't think he would have second guessed that the death of the parent could be harm. I think he was concerned with the 6 weeks.
Okay, so let me just ask it as a hypothetical, because
Sure.
I know we're dealing with this case. But let me ask, the grandparents come in, no expert, our son died, and we used to have this level of relationship with before, including some time in which we were the primary, for part of the week, primary caregivers, etc. And we no longer have that. Is no expert, could that create a particularized showing of harm?
Absolutely, and I think it's pretty similar to the RK versus DL fact pattern, which I think is a textbook example of what is a prima facie case. You had in that particular case the child actually living with the grandparents for 6 years of the child's formative years. Then the parent dies, and at first they do have some visitation, but over the course of the next year, the visitation is gone. The telephone contact ends. That's a prima facie case of harm.
So you're saying you don't need to say, this is the injury to the child, this is the psychological impairment, this is the physical damage, you need to describe a set of facts that satisfy a threshold that is not necessarily related to the physical or mental health of the child.
That is correct, Your
Okay.
Honor. That's my
Right.
interpretation of the case
And
law.
of course, if you had a situation where there was some visitation going on, or as in our case, now only limited telephone, and you have a quote from the child, "Oh, Granddaddy, I wish I could see you again. I miss you so much," it adds, now we have that particularized longing from the child.
I would agree.
But when you have nothing,
I agree, Judge. And this comes back to why we hate bright line rules
Yeah.
in family part, because the particular facts of the case dictate what the result should
And
be.
how long should the parents wait? So I understand on the one hand, Judge Curry would hope that the parties can work it out among themselves rather than drag this through the legal system. But on the other hand, the visitation rights of grandparent statute has as a fact that the time which has elapsed since the child last had contact with the applicant, suggesting that the longer the period in which you don't have contact, the weaker your case is, right?
That's what the statute says. I will remind Your Honor, it's a best interest test, though, so we're talking about before we get to the
But
statute.
even for harm purposes,
For harm
the longer
purposes.
you haven't seen the child, then the argument will be, well, you didn't have a relationship with the child for this period of time. What harm could the child have?
I think
suffered?
in a case where there's a relationship for 6, 8, 10 years, and suddenly there's 5 or 6 months and there's contact has been cut off, that's a much different
But
standard.
if it's clear it's been cut off for 6, how long does the party have to wait if contact is effectively completely cut off?
You know what my answer is going to be. You've heard the State Bar. We do not like
Depends.
bright line rules, Your
And
Honor.
it's
We
a case-
can't-
it's
we
a
can't-
case-by-case
It's no different than
determination.
alimony. Is a 15-year marriage long enough? We case-by-case basis. If you're asking me my personal opinion, with the caveat it's not the Bar Association, I tend to agree with Judge Curry on this particular case that 6 weeks was too quickly. It did not
Okay,
appear that it was cut off with finality, and the child had actually seen the grandparent in the interim period.
And you think that would that be a basis for dismissing the complaint?
Because, yes, Your Honor, because going back to what the harm standard is on these cases with the death of a parent, generally speaking, they recognize that there was a relationship, the parent dies, and now the contact with the grandparents has been cut off with finality, or the visitation is insufficient to maintain the relationship with
Justice
that
Long
son.
and Moriarty had 2 scenarios. One, the complete cutoff, and the one where you're just giving a little bit of visitation.
Yes,
And she used the same harm standard.
she did.
So she was able to foresee the circumstance where a fit parent is just opening the spigot just a little bit, perhaps hoping to cut off court intervention, right?
That absolutely could be a concern, but Your Honor, I would just want to go back to one thing. We're talking about a fit parent deciding what they think is in the child's best interest, and it's supposed to be a very high threshold for the court to second guess that.
No question.
So
On
you
that
could-
issue, I'm sorry.
Go ahead.
On that issue, and I'm not sure this is germane to the ultimate outcome. I'm just curious. The Appellate Division commented on the trial court's encouragement of mediation. When you talk about 6 weeks, it's probably pretty quick. Did you have any issue? I know this is not your subject. I know it's not what you came here to speak to. But did you, on behalf of the State Bar or just on behalf of yourself, have any issue with the trial court encouraging mediation in this case before they come to court?
I didn't in particular, Your Honor. I think what the court was suggesting in its decision when it was dismissing it on the basis of the 6 weeks, and reading that decision, I think that was the basis. I think he found 6 weeks was too
Okay.
fast. I think he was warning the mother that if they come back and you have cut off visitation, that I'm going to reopen this. And I think by the same token, he was encouraging them to try to come to a compromise position.
Did you understand the Appellate Division's issue with the trial court's suggestion that they try mediation?
No, and I'm glad you raised this, Justice, because there was one point I wanted to actually clarify. In the Appellate Division decision, in RK versus DL, I believe it is, or actually I think it was this case, it's talking about Wild versus Wild and trying to distinguish Wild. I think sometimes when we have transcripts, it doesn't necessarily show when a judge is quoting from an Appellate Division decision. And he was reading word for word. I don't remember if it was from Daniels versus Daniels or Wild versus Wild, but he was reading word from word what the decision said. And I think that the Appellate Division, I'm assuming this, got a little confused and thought those were his words when it was actually another Appellate Division panel's words that had already been
Thank you,
written.
that's helpful.
That explains it.
Yeah.
Thanks.
Can you come back to Justice Patterson's question earlier in the argument? You've given us two fact patterns for particularized harm. What else should we look at? What else? Other factors that would make up for a definition of particularized harm?
You know, I knew I was going to be on the hot seat for this particular question, and when we were writing the brief, there was discussion on whether or not we were going to ask the court to do that, because we could not come up with other fact patterns ourselves besides the two that I've discussed, the psychological parent type relationship and the death of a parent and the termination of a relationship. I do remember, and I don't remember where the state, we didn't cite it in the brief, there is a case out there that talks about a very unique situation where a mother who had primary custody and sole custody of a child dies. The father, as the fit parent, then receives custody of the child. The child was deaf. The father did not know sign language. The grandparents knew sign language. The father didn't want to have visitation. The court found because of the sign language issue, it was important for the child to still have visitation with the grandparents. That's the only other type of situation, and it's such a unique factual circumstance. That's why I go back. The case has to speak for itself.
How about where, and this is something that's mentioned in a couple of the cases, how about where a cultural heritage is only found on one side of a family? And that's something that the child has from the now deceased parent, who's no longer able to provide that cultural heritage to the child. Would that create a scenario where a particularized showing of harm might be met?
I think under the right fact pattern, I think that probably could, Justice, especially if the child was practicing both religions or both heritages, and now suddenly it's going to be stopped and the other parent no longer looks to continue down that path. I think it could be under the right circumstances.
Anything you'd like to add to your presentation?
No, thank you very much.
Thank you very much.
Ms. Newmark.
Good morning. Based on the questions, I'm going to change my argument a little bit.
Great.
The Appellate Division correctly recognized that the majors claimed enough in their complaint, their written form complaint and their amended complaint orally, to have standing. They set forth the prima facie case. The Appellate Division correctly recognized that the trial court in this instant erred not only as to proper procedure, but as to the substantive law as well. And its dismissal of the grandparents' case at its inception was a denial of their due process right to proceed. But that doesn't really deal with the bigger issue and the questions that are being proffered today and why certification was granted by this court. I want to submit, petitioner argues that there's this conflict that's created between the RK case and the Moriarty jurisprudence. It's simply not accurate. RK does not change the law. What RK does is provides a procedural roadmap for the trial courts to employ. RK recognizes that Mandate 0811 in 2011 that put the grandparent visitation cases in the FD court created a disconnect. A grandparent case, by its very nature, requires initial burdens to be vaulted by the grandparents before that they can seek relief under the statute. That's Moriarty. That's Justice Long's opinion. Yes, it's not a contest between equals. Before the grandparent can seek visitation in accordance with the statute, we know that they must vault the presumption of the fit parent. With those initial burdens, it's not workable to have them in a check the box, and if you want to add a few more sentences, use this page. I reference you to dependence, I think it's DA 64 to 66. Use these pages, and then you show up to court, and it's a summary proceeding. It's not workable. Today is your day. There's no motions. We're here for our application. RK recognizes this doesn't work. Trial judges, in the trenches, we are giving you 7 tools, because the first, I remind this court, is identifying the harm to the child. We're giving you tools to use. With respect to the floodgates of litigation argument that has been asserted by the petitioner, it's a bit of an overstatement. It's somewhat of a Chicken Little argument. The sky is not falling. Post-Moriarty, factually, very few cases have been filed in this area. RK doesn't change the law, so there's no suggestion or any evidence that now floodgates will suddenly open. And I'll remind this court, there's no blanket entry for a grandparent. And this is where I'm going to go to Justice Alvin, your question and the question that's been proffered several times this morning. The Moriarty hurdles remain the same. And if we read Moriarty, Justice Long, in writing for the court, sets forth specific examples. Death, divorce or separation where visitation is denied, or the termination of a long-standing relationship. If we fast forward the clock, and I'll get there later in my presentation, but if we fast forward the clock to 2010, this very court, in the In re DC case, talked about this established relationship. Moriarty touched it when it talked about, well, the trial judge, he had pictures, this was a very close and established relationship. The Daniels case, which was a very distinguishable pre-Mandate 0811 case where both parents were alive and united in their position, that grandparents were out of the picture. But in Daniels, it talks about you have to have this close bonded relationship. In re DC, this very court, it's a sibling visitation case, but this very court considered the issue, and it was ruled the relationship must be of such a gravamen that a harm would result to the child if the visitation is denied. So what do you have? You have to have this established relationship, and you have to have a circumstance of a death, divorce or separation where visitation is denied, or the termination of a long-standing relationship. So what does that do? That eliminates the grandparent who has no relationship with their grandchild and is now showing up for visitation. Grandma who found out her son had some romantic encounter 10 years ago and now wants to meet and have a relationship with her granddaughter, she's out. She's out of the box. Her complaint will fail on its face because it can't set forth a prima facie case. So the floodgates are protected. That's a non-issue. The right to discovery. Considerable concern has been presented to this court as to what is the right to discovery. I would submit, Justices, in Moriarty, the law was made very clear. We have the grandparent and sibling visitation statute, but before you can award visitation and complete your analysis of that, you need to have the one of 3 hurdles. RK does not change that. What RK does is it gives the tools. It gives the tools that may be necessary. And why is that so important, and why is that such a recognition? Justice Alvin, I think you connected the dots. Mandate 0811 made it summary. It's not a domestic violence case. This is when you're dealing with the child, most paramount, the most important thing, the interests of a child. You're showing up at FD court for an application. And as the trial judge was mistaken here, well, today is your day, there's no motions. Rule 554 kind of went out the window. RK brings it back and it says, listen, trial judges, see if the parties can stipulate to any of the facts. That's one of the tools. See if an expert is required. It doesn't say you have to have an expert. It doesn't say you have to have 2 experts, 3 experts, a guardian ad litem. It's left to the judge's discretion based on the facts of the case. Discovery says, what discovery do you need? And it's left to the judge's discretion based on the facts of the case. RK goes even farther, though, with the tools and the rights to discovery. It says, trial judges, you must protect the law. They cite to Moriarty. You have to understand the Moriarty hurdles. But you must also strike a proper balance between the grandparent's right to present their case, because, Justice Patterson, as you said, what's the point of having a statute and having rule if it's insurmountable? You must respect the grandparent's right to present their case. You must respect a parent's fundamental right to parental autonomy, and you must also protect the child's their right to privacy. You have to do a balancing test. And here are tools to enable you to do this as you navigate through the very crowded FD system where you're showing up for court for applications. It's an acknowledgement that the check-the-box notice pre-done complaint is unworkable. You have to set forth a fact-specific complaint.
Okay, let's start there.
Okay.
Let us assume that as of now or going forward, there is no inhibition to filing a real complaint that sets forth the parties, the facts. You're not checking boxes, and you're not giving 3 lines to set forth your case. Let's pretend we're beyond that, because we know in RK they had a lot of problems with that. I'll save my editorial comment. So you are now able to do what what any attorney would do, filing a complaint. This is who we are. This is who the defendant is. These are the circumstances. These are my facts. This is the relief I want. Okay. So now you've filed a real complaint.
Facts complaint. Yes.
What has to be, what do you, in this context, given Moriarty, what do you have to assert to knowing you have to get over a hurdle?
Okay. I'm going to answer this question because it's been proffered twice already, and I'll give you what I believe needs to happen for clarity. The identifiable harm to the child, incorporating the 3 examples, because this is not a carte blanche situation. Death, divorce or separation where visitation is denied, not, rent day. Well, we're getting divorced, I'm the supervisor, I want time on the alternate weekend. Death, divorce or separation where visitation is denied, or the termination of a long-standing relationship. With that, use your existing law, in re DC, an established relationship of such a gravamen that a harm would result.
And do you say that in a conclusory fashion, or are you going to elaborate in that complaint? Throw in some facts.
It's a prima facie complaint. So you can throw in a couple of facts, but it's prima facie. You're coming in at its inception.
Are you saying then that if you, in this situation, you assert, we are the parents of John, who is the father of Joan, and he died, and we want visitation, that gets you over the hurdle?
No,
Okay.
It doesn't get you over the hurdle. Let me tell you why. In re DC, the appellate superior...
With the supplementation, you have a particularized complaint. Are you at least conceding that in cases of this type, you'd have to have particularized allegations?
I think the particularized allegations... It's a catch-22. How can I go if you're being denied access with the child?
No, you have them. The
Here I
particularized
do.
allegations
You have.
is about the relationship.
Right.
How profound it is, how long it is, how deep it is. those types of allegations. Would you-
Absolutely.
Okay.
Absolutely, but we had them.
But
we
you,
had
you
them
would
in
have
the-
to detail, for example, and then I think we want to get to the next step on this. You'd have to detail from 2008 to 2012 on this much frequency of visitation. Here's what we would do. We would go to Disney World. I babysat, etc. All that has to be
Exactly.
set forth by
Exactly.
complaint. Okay. Now, how do you say that grandparents could on the basis of those facts show the harm to the child?
The harm to the child was set forth by Suzanne Major in her testimony. The child has already suffered a traumatic event. State Bar talks about this traumatic event. She lost her dad, but she's now also losing her grandma and grandpa that she has seen with regularity and is incredibly bonded. If the suggestion is, in every case, do we need an expert report, go back to Moriarty. It could be expert, it could be factual. And I don't think it's necessary, but I think in the complaint, that's enough to get over the initial hurdle. Because let's be mindful, where are we going after you get over the initial hurdle? It's not an all or nothing. You have a statute, and the statute tells you, I think it's B1 or B2, tells us right then and there, well, what is the relationship between the child and the applicant? That's what we're going to take. DC fleshes it out. Daniels, the Appellate Division case that predated that, fleshes it out. But that's where we're really looking to what's required. Where I'm going to stop short and really, and I'll talk about this more if you're Justice, if you'd like, is there's this presumption where there has to be like a psychological parent or they have to live together. I'm going to direct you to Daniels. Daniels talks about Roth. I think it's Roth v. Roth. It's a Connecticut case where in Connecticut you have to have a parent-like relationship. And that's suggested by State Bar in their petition. And I've heard argument about that today. No. In re DC stops there. Daniel says, no, we do not have that. And I believe Moriarty discusses as well. We don't have that. You don't have to be the parent because it goes against the entire theory and the analysis of when we said this statute is fine. You don't have to have a parent-like relationship. You don't have to live together. It's that close bond. It's the recognition in the Moriarty court that the grandparent relationship is fundamentally different than the parent relationship. I can tell my kids to go brush their teeth and do their homework. It's different at grandma and grandpa's. That was the recognition from the experts in the Moriarty case. So those requirements that are being suggested this morning, we fall short of that. But going back to the initial prima facie complaint, it's at its embryonic stage. So all RK does is say, let's have a case management. The case is joined. You're not showing up and today is your day, here we go, it's all or nothing. We're going to properly handle the case. There's no preclusion under RK for an immediate motion to dismiss.
But we also have to relate the procedures that are being outlined in RK to those facts of RK, too.
Exactly.
Those were, I think, those are certainly facts where the child had lived with the grandparents, the maternal grandparents, for many, many years.
For a period of time,
And
yes.
clearly there was conflict, but there was between the father and the parents, and well, the mother. But the children had lived there for a long time. So we're now going to apply it to your case.
Yes.
We're going to take it to your case. But I think what you're conceding is that in your complaint, in your proper complaint, you are going to make those various allegations.
Absolutely. And I think in the pre-form, imperfect, check the box, mandate 0811, if you want to use an additional paper, use this paper. I think it's DA 66. We had a close and ongoing relationship during my son's 50% of time with this young daughter. We were there for her first 6 years of life every step of the way. She lost her daddy because he died to cancer. Now we can't see our granddaughter.
What does it, no, okay.
And in terms of the harm, I just want to go back to the transcript. Grandma did testify. I had a conversation with the therapist as a result of that. I am here. I have filed my application with the child's therapist.
How about the trial court suggestion that you jumped the gun?
Mm-hmm.
That 6 weeks, can't you try to work it out? Why are you dragging them into court and leaving the potential for you coming back if you just can't work it out among yourselves?
That's imperfect, and you're creating catch-22 because go back
I'm
to
not saying for every case.
Yeah, no,
but
but go back
case.
to In re DC. The passage of time where the sister didn't see the 5-year-old twins, was a factor that they said, through no fault of anyone, the hurdle that's being created because we now have these 5-year-old twins that are going to be adopted by the foster parents.
Why was it unreasonable in this case? Forget about DC or any other case. Why was the courts saying, I'm going to dismiss it now, and hopefully you people will be able to work this out among yourselves? Why was that unreasonable?
The judge approached it he was substantively wrong, and let me tell you why. Number one, before I even get into procedure, the judge applied, instead of an avoidance of harm standard, requisite harm. If you read in the transcript, the judge says, well, you had an obligation to provide requisite harm. Two incredibly different burdens. Secondly, the judge, you're right,
I'm sorry, can I interrupt you on that? What did that mean, requisite harm?
He never defined it. But the standard is avoidance of harm, not requisite. If you look up the word requisite, it's a prerequisite. It's a much higher burden than potential for. So very different. Then we fast forward, and he cites to Wilde. Well, Wilde predates Moriarty, so I believe it's sub silentio. But the Appellate Division cleaned it right up in the footnote where they said, wait a second. The judge cited to the Wilde case, which was citing to Justice Kennedy's remarks in Troxel. And the appellate court said, we cited to that case in Wilde, to those comments of try and get along, in our decision to retain original jurisdiction and not remand it back down. So you can't pick and choose dicta what fits and doesn't fit. And that's part of my concern, which was what's happening. So that was his second big error. Mediation is great. Waiting 6 weeks, 12 weeks, 14 weeks. Here we made a decision to file our application right away based on a communication with the child's therapist that grandma needed to remain involved in her granddaughter's life. So she made a decision. But that's not a basis to dismiss a prima facie case which existed. These grandparents are clones of Moriarty. They're clones of them.
So you agree with the State Bar Association that the question is there a risk of harm to the child, and that is established once you show death of the parent in this case and a close, very close relationship between grandparent and grandchild. You've made your prima facie case, there's risk of harm, we go to the next step under RK.
Exactly. I completely agree with that. What I think needs to happen is somehow these cases have, based on petitioner's brief and State Bar's brief, I think some of the cases, things are getting lost in the sauce. RK gives us the procedural roadmap. It's clear. This is what you can do, judges. I would submit at this time, this court should reiterate the existing law. It's not...
So the trial court's, and I don't mean to interrupt you, but
No,
I'm just
interrupt
to
me.
get it clear in my head. So the trial court's error, one of the key errors in the trial court, your position is that the trial court required that harm to the child be demonstrated. Some harm has occurred rather than risk of harm based upon these facts alleged.
I don't even think, and I mean this very respectfully to the
Please.
trial judge because I appear before him and he's a very smart
And
judge.
he'll hear
but-
about this.
No, but in this particular, so I say this with all respect, in this particular case, if you have to show avoidance, but the trial court thinks it's requisite harm, you're set up, like you said, Judge Patterson, it can never be achieved.
In this case, had the judge not dismissed it, but said, before I make a decision about the merits of the complaint, I'd like the parties to go to mediation, would you find that a problem?
We beg for mediation. That's an arcade tool, and that's a smart tool, because the reality of the situation is mediation works. But if you're coming in believing...
But the other side would say, well, if you don't have a prima facie case, you shouldn't be dragging me into mediation.
If the judge would have said, you have a prima facie case, now, arcade didn't exist, so we can't fault the trial judge for this. Go out, and we're going to mediate the case, and we're going to see if that works. Sort of like in the divorce world. When custody is an issue, we have this requirement that we go to the custody and parenting time mediation. I can tell you in my practice, many cases resolve themselves there. So yes, that is a workable tool. I'd want to go back to one more error of the trial judge that I think was significant, which is also why they never got their day in court. The judge was of the mindset that the visitation, if you read in his decision, well, the visitation has to be denied with finality. Not so. Moriarty says the opposite. And I think Justice Cuff, you commented on this. Moriarty's, Justice Long said, well, if it's not to the satisfaction to the grandparents, the same analysis applies. Those are the instances where the faucet's left just enough so there's a trickle, like in this case, where they've seen their daughter, their grandchild, 45 minutes this year. It's insufficient. But that's the instance where you can still have the Moriarty analysis. But that was the other significant error. So here, putting the procedure aside, leaving the expert in the hall, never ruling on the motion to dismiss that was filed by petitioner that remains unresolved. There was never a Brill analysis or anything like that. Forgetting the procedure, substantively, it was off the mark as well. But that also ties into, well, what do we do going forward? Like I said, RK gives the procedure. So when we're in the trenches, now the judges know, the lawyers know, we all know what we need to do. I don't necessarily think we need a twofold, automatic, two-step proceeding.
No, what the State Bar is saying is simply is this. The stage one is, have you set forth a complaint that establishes the cause of action? If you haven't, there shouldn't be discovery. That's all they're saying.
I agree with State
Then you
Bar.
agree with them.
I agree with them. I disagree. We part company as to their endorsement of the trial court's procedure and conclusions. The reliance on the cases post-Moriarty, it needs to be clarified. Daniels. There's a lot of discussion in the briefs and stuff about the Daniels case. Let's remember, Daniels was an intact family where the parents were united. They're both alive. They're together. They're united in their position. That grandma and grandpa, they're out. And the judge reasoned in that case, you need to have a close and established relationship. Here, the parent always had a very strained relationship with the grandparents. So they were in and out, in and out, in and out. So as a result of that...
I'm sorry, what are you saying?
Daniels. The grandparents and the parents, they've always had this strained relationship. So they were in the life, out of the life, in the life, out of the life of the grandchildren. So grandparents never had that close and established bond.
You're not talking about your own case, you're talking about
No,
Daniels.
I'm talking about Daniels. Here, there couldn't be any closer. I mean, this is, let's go to grandma's house in Maine, let's go to Disney, here every step of the way, for the first 6 years of this child's life. So here there was an exceptionally close relationship. I just wanted to distinguish it, and this is also pre-mandate 0811. So you can't fault the litigant for using the form complaint when the mandate says we have to because we're now in summary court. The reliance on the Rente case. Again, Rente stands for the prime proposition of, in that case, the judge said, I don't think you have a prima facie case, but I'm going to award some visitation. And we're going to move forward. We'll have Dr. Dasher come on in. In that case, both parents were alive. Dad had supervised visitation. I believe the child was 2, very young. And Dad had supervised visitation. Grandma was the supervisor. And then she wanted visitation on the alternate weekends just for herself. That's very distinguishable. And that's not what I'm suggesting here. And that's why I submit to this court, use the Moriarty examples and redo the requirement of In re DC. Take Daniels to the next level, which was already done in the sibling visitation case, and now you've protected it and you have clarity.
Should there be a substantively different rule for death cases? And by that I mean one parent or the other has passed away.
Yes, but that would be inclusive. It's not necessarily the death. It would be death, divorce, or separation. There are instances where, like here, Grandma and Grandpa Major.
Moriarty has already said those are special categories.
Exactly, because it's a denial. If Dad was still
What
alive...
I'm asking about is within the 3 Moriarty categories, does the scenario presented by this case in which the grandparents have lost their son, the child has lost one parent, who is the connecting parent to those grandparents, should those cases be handled differently than even the divorce separation cases where both parents are alive?
Not necessarily, and I'll tell you why. It's a traumatic circumstance. It's really about the child. This child's going through a traumatic circumstance. So losing a parent is traumatic. It's terrible. But mom and dad getting divorced and one parent being tossed out and not seeing that parent again, that's traumatic. That's terrible. I don't want to say what's the worst of the traumatic events, but it's really looking at a traumatic event to this child.
But you still have to have a pre-existing relationship with the grandparent.
Absolutely. That brings me back to the example of you got to protect your floodgates, and you're doing so already without even realizing it, because grandma who finds out, oh, by the way, my son, he had this encounter, and now I have a granddaughter who knew I want to have visitation. She's out. You have to have the significant established relationship. That's not grandma and grandpa who, are living in Florida and come up when the child's born and then see the child again 3 years later. I'm talking about...
And we're, just to be clear, we're just talking about the hurdle that's necessary to survive a motion to dismiss a complaint. We're not talking about the merits of a case.
Oh, absolutely. Judge, this is only to get over the initial hurdle. All of this is just to get through to the statute. Because let's be mindful. The statute wants to know what's the relationship between the applicant and the child, and what's the relationship between the parent and the applicant.
Ms. Newmark, I think we have the argument. Is there anything you wanted to add?
Just that the decision of the Appellate Division should be affirmed, but I'm going to take it a step farther. Grandma and Grandpa Major, as a result of this case progressing through the legal channels, despite the remand and the reversal by the Appellate Division, have seen their granddaughter for 45 minutes this year. We would want interim visitation to be awarded as part of anything, because the passage of time, as we've learned in D.C., doesn't help anything. Thank you, Justices.
Thank you. Ms. Lyons, rebuttal.
Respond very quickly, if I may, Your Honor. First, we ask that any reference to the statement of the therapist be stricken. Judge Curry himself struck that. It has never been proven what the therapist may or may not have said. Next, the question of why did Judge Curry use the word requisite harm? We believe that he meant a showing of harm. We don't believe that he was intending to create a new standard. We agree with the bar. I've thought about it some more. I've listened to some other people here as to what would be prima facie harm. I think, number one, if the grandparents were full-time caregivers, that's the psychological parent. I think that's one prima facie showing of harm. I actually agree with the issue that was raised. If there's a cultural issue, if you have one particular family where they speak, particular language, and the cultural issue, I think that might be prima facie. And I think the third one would be what the bar indicated, that is death plus the cutting off of the visitation. It's not death plus a good relationship. It's death plus the cutting off. I would submit those...
Is 45 minutes over a year cutting off or
not? Judge, we don't submit it's 45 minutes, and if Your Honor looks, they've been offered more. They just haven't taken it. They were invited to the child's birthday party. They chose not to come.
Let's stay away from the facts here.
I was asked.
I think the question goes to, does it have to be a complete cutting off, or can it be a serious limitation?
I think it can be a serious limitation if it is through the fault of the fit parent. Next, very quickly, we agree that the trial court, when he was talking about mediation, was referencing Wild. We believe that's appropriate. And you want to talk about the notion...
You're not suggesting... Are you suggesting that mediation is okay before the judge determines the validity of the complaint?
No, I am not, Your Honor. What I am saying, however, and it's interesting because I think RK itself, though, says you need to consider whether the grandparents have shown good or bad faith. As the court probably knows, even in particular with this case, after the Appellate Division reversed, grandparents filed an application in this case asking the fit parents to pay $13,000 in counsel fees. I think the good or bad faith, I think that plays into it. Very lastly, two very quick points. One, RK is unconstitutional. RK is unconstitutional because you first need to analyze factor one, the harm, and we gave 3 examples. Only after proving the harm with those 3 examples do you get to 2 through 8. If you get to 2 through 8 before proving factor 1, it's unconstitutional.
Do you
Finally,
have to prove harm or establish a prima facie case of harm?
Your Honor is correct. Establish a prima facie case of harm. And the way you can show a prima facie case of harm is the 3 examples that some of the 3 examples that we gave. Finally, respondents referenced rente and how rente doesn't apply because in that case we had 2 fit parents. I would remind the court, and it's noted in the brief, that this child has since been adopted by her step-parent. This step-parent is now the other fit parent of this child. This child does have two fit parents. So, and that was mentioned in the brief, because that happened subsequently. So if they're going to say, oh, well, you can't look at rente because that was two fit parents, this child has two fit parents.
Thank you. And
Thank you.
Thank you to all counsel for the helpful arguments. We'll take the matter under advisement, and the court is in recess until 1 o'clock.